Justice delayed, justice denied. The plight of sexual assault victims in Saskatchewan is a grave issue that needs immediate attention. The justice system in Saskatchewan is failing victims of sexual assault, leaving them in a state of limbo. This year alone, a staggering 1/3 of sexual assault cases were dismissed due to procedural delays. Why? Because they took longer than 18 months to reach trial, a delay that is both unacceptable and heartbreaking. Behind each dismissed case is a survivor denied their day in court, denied closure, and denied justice. These are not just numbers. They are real people with real pain. The right to a timely trial is a cornerstone of any fair and just legal system, a principle that should be upheld without exception. When this right is violated, it sends a chilling message to survivors that their trauma doesn't matter, that their suffering is insignificant in the eyes of the law, that their voices don't matter, and that their quest for justice is in vain. This is the harsh reality for countless survivors in Saskatchewan who are left feeling abandoned by the very system meant to protect them. Where a backlog of cases and systemic inefficiencies have created a perfect storm of injustice, leaving many without hope. Survivors are left to navigate the trauma of sexual assault without the support and validation of the justice system, a journey that is isolating and painful. The perpetrators, emboldened by the lack of accountability, may go on to harm others, perpetuating a cycle of violence. This is a crisis that demands our attention. We must demand action for the sake of the survivors and for the integrity of our justice system.
The reasons behind these unacceptable delays are complex and multifaceted, involving a range of systemic issues that need to be addressed. Court scheduling is often inefficient, with cases being bumped or delayed for a myriad of reasons, including overbooked calendars and last-minute changes. The procedural systems in place are often cumbersome and time-consuming, adding unnecessary layers of bureaucracy that slow down the entire process. Pre-trial applications, while sometimes necessary, can also contribute to delays, creating bottlenecks that hinder the progress of cases. As can difficulties in securing legal representation, which is a significant barrier for many individuals seeking justice. The wait times for forensic evidence, such as DNA analysis, can be excruciatingly long, further delaying the resolution of cases. These systemic issues are not insurmountable, and with concerted effort, they can be addressed. The government of Saskatchewan has a moral imperative to address this crisis and ensure timely justice for survivors, making the legal system more efficient and accessible for everyone.
It is a tragic reality that sexual assault is a vastly underreported crime, affecting countless lives in silence. The fear of not being believed, of being blamed, of enduring a lengthy and re-traumatizing legal process prevents countless survivors from coming forward. This fear is compounded by societal stigma and the potential for public scrutiny. When the justice system fails to hold perpetrators accountable and allows cases to drag on for years, it sends a dangerous message. It suggests that justice is elusive and that the system is not designed to protect the vulnerable. To survivors, it reinforces the belief that their experiences don't matter, that their voices won't be heard. This can lead to a sense of hopelessness and isolation. For those who do find the immense courage to come forward, the journey through the justice system can be a harrowing experience. It requires strength, resilience, and often a support system to navigate the emotional and legal challenges.
Section 4, a call to action, demanding accountability and reform. The current state of affairs in Saskatchewan is unacceptable. We as a society cannot stand by while survivors of sexual assault are denied justice. We must demand better from our elected officials. We must demand accountability. We must demand reform. This includes increasing funding for the justice system, streamlining court procedures, and providing specialized training for judges, lawyers, and law enforcement.
Section 5, towards a survivor-centric justice system, hope for the future. The ultimate goal must be to create a justice system that is truly survivor-centric, a system that prioritizes the needs and well-being of survivors above all else. This means ensuring that survivors have access to adequate support services throughout the entire legal process. This is not just the responsibility of the justice system, it is a collective responsibility that we all share.
Section 6. The power of public pressure, a collective responsibility. Change does not happen in a vacuum. It requires pressure, it requires action, and it requires a collective voice demanding justice. The people of Saskatchewan have the power to be that voice. We must hold our elected officials accountable for their inaction. Write to your MLA. Share your stories. Demand change. The time for change is now.